once again. I don't know what's going on today. We can't go live, so I don't know what's really going on. So we have to proceed to make the video now. 2 days ago, we talked about bankruptcy protection. Today, we're talking about bankruptcy protection 2. It's like the episode 2 of the same topic. So I would like to brush through it quickly. A debtor must file a petition to begin a case with the federal bankruptcy courts, at which time he gains temporary protection from his creditors. What does it mean to gain temporary protection from your creditors? It means they won't be able to take actions against you nor confiscate your property. Dependent upon the type of bankruptcy case, usually Chapter 7, 11 or 13, the bankruptcy court can assist the debtor in restructuring his debts into more manageable obligations, meaning a schedule favorable to the debtor. That is, for example, if he or she is owing an income of about $300,000 within a 5-year period, he or she can be made to pay $5,000 monthly. You can also discharge the debtor afterwards, or even order the sale of assets to help creditors recover money owed to them. Debtors often seek bankruptcy to create a fresh start from their current financial pressures. To benefit from the process, bankruptcy, that is the process of bankruptcy protection, a debtor must first begin his bankruptcy case by filing a petition with his local federal bankruptcy court. That is, what is a local federal bankruptcy court? That is a bankruptcy court in your district. That's why I say it's meant to be handled by a lawyer in the US, because they will be more able to break down these little terms into their simplest bits for us. The bankruptcy case immediately provides the debtor with protection which prevents, after its commencement, which prevents creditors from attempting to have the debtor pay all his debts until the case has been concluded. This means that when the case has commenced, you don't repay any debt until it has come to an end. The commencement, that is this activity, also defines the assets, the obligation, and financial conditions that the bankruptcy case will address, otherwise known as the property of the estate. Leases and certain contracts can be important parts of a bankruptcy case. This type of bankruptcy case is prevalent today because it allows eligible debtors to extend their debt payments periods and lower the interest rates on their current debts. However, another large benefit of some bankruptcy case is that it can allow the debtor to keep his property, such as a house or a car. It does this by requiring the debtor to adopt a plan that restructures payments of current debts over a 3 to 5 year period. Presumably, if some debtor properly completes his plan at the end of the period, he will receive a discharge from the affected debts. Additionally, persons are eligible only if they have unsecured debts less than $141 million, that's about $360,000, and secured debts less than $1 million, that's about $422 million. Without meeting these requirements, a person may not file petition for Chapter 13 bankruptcy and must seek other bankruptcy categories. Thank you very much for listening. God bless you.